Good afternoon, good evening, and even good early afternoon, let's say. In Canada and in Bulgaria, here in the Netherlands, for the Quarks Foundation, my name is Aurélien Lorange. We'll have an eighth of finals match between two teams, and I give the floor to my colleague who will be hosting the match.
Thank you very much, and really good day, everyone. Welcome to the eighth finals match between the University of Manitoba, joining us from Canada, and Sofia University, joining us from Bulgaria. I believe it's about lunchtime in Winnipeg and evening in Sofia. So, hopefully you've had a good day so far, and it continues going well. So today the teams will debate on the topic they've received 7 days in advance, specifically on the topic that sports leagues should implement a policy against players and coaches disclosing injuries and other medical issues on social media. As always, we'll find out which team will represent which side of the argument after the introductions. And thus, without further ado, I would like to give the floor to University of Manitoba's Mr. Harris.
Hi, good afternoon and good evening to my colleagues in Bulgaria. It's a pleasure to be here in this eighth final along with my teammates at the University of Manitoba. My name is Samir Harris, and thank you for hosting this event. We're very excited.
Thank you and welcome. From Sofia University, Ms. Mukachan.
Good evening, Bulgaria. Good afternoon, Canada. I'm enjoyed to be here. I'm Teresa Mukherjee from Sofia University.
Thank you and welcome. From University of Manitoba, Ms. Andrews.
Hi, everybody. Good afternoon and good evening to our friends in Bulgaria. Thank you guys so much for agreeing to meet and to debate with us. We're very excited to get it underway and see what ends up happening. Thank you.
Thank you and welcome. From Sofia University, Ms. Angelova.
Good evening, everyone. My name is Maya. I'm in my second year of law school. Today I'll be representing Sofia University and I'm looking forward to our debate.
Thank you and welcome. From University of Manitoba, Mr. Bullard.
Hi. Yeah, likewise, happy to be here. Thank you for everyone joining us, and thank you for our colleagues for accommodating our exam schedule. I also finished my first year of law school. I'm just excited to be here.
Thank you and welcome. I would like to also take this moment to give a shout out to the mentors for the two teams. University of Manitoba is mentored this year by last year's former participant, Ms. Diana Gutierrez. And Sofia University also has a returning mentors, Sofia Donskaya and Mr. Kuchikov, both of whom are currently on the call with us. So if you would wish to share some words of encouragement for the students debating today.
Hello, everyone. We're very thrilled to be here, and we're hoping that we'll see some great debating skills between the two teams. Good luck, everyone.
Yes, as my colleague already shared, we're very, very excited and we hope the match goes well. Can't wait to see the positions of all the participants.
Thank you. So in a short while, you should see the wheel for the allocation of the positions. If you could just give me a confirmation when you can see the screen.
Yes.
All right, thank you. So as always, there are four possibilities, two possibilities for each team. And today's debate will be argued and argumented with Sofia University defending the position in favor and thus arguing that sports leagues should implement a policy against players and coaches disclosing injuries and other medical issues on social media, whereas the team of University of Manitoba will argue against this motion. So you will now have 5 minutes to finalize your preparations. Feel free to close your cameras, and once the timer runs out, the team in favor will start the debate. Good luck. All right, thank you everyone. The final time for preparation is now over, and we will be proceeding with the opening statements in the favor. So, giving the floor to Sofia University team, you have 4 minutes.
I would first like to ask if I'm audible and visible.
You are, thank you.
Good afternoon to the fellow judges and to my colleagues from University of Manitoba. On behalf of myself and my teammate Teresa, we're very pleased to discuss the need to implement regulations in the field of sports injury disclosure. As enshrined in Article 141 of the Olympic Movement Medical Code, the medical conditions of players is personal information that stays between the doctor and the patient. Today, we support the notion that sports leagues should implement a policy against players and coaches disclosing injuries and other medical issues on social media. We will present three main arguments. First, we will argue that such regulations will provide for a better privacy protection of the player. Secondly, the lack of regulations can create opportunities for potential manipulations of the matches. Lastly, unregulated public disclosure of injuries could impact the sponsorship of the players and the team. Turning to our first argument, namely, that the lack of regulation will lead to potential violation of the right of privacy of the players. According to Article 17 of the International Covenant on Civil and Political Rights, no one shall be subjected to unlawful interference with his or her privacy. Furthermore, Article 8 of the European Convention on Human Rights sets out the right to respect for private and family life. We rely on the definition for privacy provided by the Oxford Dictionary, which states that people should be, and I quote, free from public attention as a matter of right. End of quote. And while the opposition might state that since players are considered to be public figures, thus their right to privacy is limited, we cannot agree with that. In a recent case, von Hanover versus Germany, the European Court of Human Rights ruled that public figures, even such as the Princess of Monaco, have a right to privacy and protection from intrusive media coverage when engaging in private activities, and medical injury is such. It is clear that social media is a platform which dispenses information to a great amount of the public. Thus, in case a coach is provided with the right to freely decide whether or not to share sensitive information, such as a medical record, this could be considered as an unlawful interference of the player's privacy. For that reason, regulation is of the utmost importance when it comes to sharing such information online. With that, I would like to move to our second point. We argue that the lack of regulations could lead to misinformation and therefore manipulation of the match's outcome. In team sports such as football or volleyball, the creation of game strategy is highly important. In team sports, this strategy is decided on a case-by-case basis, depending on the opposing team. And consequently, by not regulating the disclosure of such informations, players and coaches would be free to provide any statement, including false one. By providing false information about an allegedly injured player, the opposing team could be misled and predetermined to failure. As a result, sports leagues have the authority to establish and enforce their own policies and regulations, including those related to player conduct and communication. Providing such jurisdiction to sports leagues is a practice of numerous states, such as the United States, the United Kingdom, Brazil, and Spain. Thank you.
Thank you very much. We'll now hear the opening statement in the against position. University of Manitoba's team, you have 4 minutes.
Hi, I'd like to confirm that I'm visible and audible.
You are, thank you.
Thank you. In 1946, a bookmaker attempted to fix the NFL championship game by offering bribes to players to claim an injury. Since then, leagues across the world had begun to require teams to report injuries in order to keep from profiting from inside information. In order to affirm the primary need for sports to be competitively fair, we negate the proposition the sports league should implement a policy against players and coaches disclosing injuries on social media. We set out two reasons for our position. First, allowing disclosure of injuries on social media is necessary to promote competitive fairness. When injuries are provided in an open, public manner, the efforts of gamblers to attain and profit off insider information on player availability is severely limited. If injuries are not reported publicly, there are many modes of uncompetitive practices which may occur. Gamblers may pay teams to sit players out of crucial games under the guise of injury, and the injuries are not objectively verifiable without public disclosure. And to promote publicity and drama, leagues may look the other way to injury reporting requirements and allow for teams to exploit player availability for their own competitive advantages. Thus, detailed public disclosures of injuries on social media creates an objective record by which anti-competitive practices can be monitored and brought to attention. Finally, it is in the spirit of competition that competitors disclose their injuries publicly. It allows teams to effectively prepare and strategize for their game, and for spectators, it allows them to predict whether the athletes they want to watch will be available for their entertainment. Secondly, the health of sports and the players themselves necessitates public disclosure on social media. To promote athlete safety, there's a need for publicly accessible data in order to analyze and recommend necessary changes. For example, UEFA instituted a study to gather data on the effects of playing on artificial turf versus grass, when in a football match are injuries more likely to occur, and at what points in the season are players at increased risk of injuries. The resulting reports from team data were used by clubs to make adjustments to their own tactics in order to prevent injury. Data such as this is also used to increase the safety of sports as a whole. After research found that soccer players were more likely to have Alzheimer's due to heading the ball, the Scottish Football Association banned children under the age of 12 from heading the ball in training. It is not only necessary that the information be collected, but also that the information is posted on social media and is accessible by the public. It cannot be assumed that governing authorities of sports will consider the data in good faith and make necessary changes to protect athletes. For example, the NFL initially tried to dismiss and hide third-party research that demonstrated that football athletes suffered from devastating long-term neurological effects as a result of the sport, but then were forced to admit the connection and make changes to the rules of the sport. If the data underlying this research was limited to the league, it is unlikely that this health risk would either be recognized or acted upon, such that unnecessary harm would be continued to be caused to athletes. Finally, it is not contested that social media creates unnecessarily speculation about injuries that is harmful to athletes. However, the best way to tackle speculation and disinformation is to be outright and transparent with the injuries. To conclude, sports leagues should not enact a policy that prevents players and coaches from disclosing injuries on social media, as not only is disclosure permissible, it is necessary for the health of the sports and athletes. Disclosure on social media promotes and ensures fair competition, and it allows for sports to become safer over time due to data based on those disclosures. Thank you for my time.
Thank you. We have now heard the opening statements from both sides of the argument. We'll now proceed to the rebuttals. Starting with the team in favor, Sofia University, you have 2 minutes for your first rebuttal.
Am I audible and visible?
You are, thank you.
Turning to our third argument, unregulated public disclosure of injuries could impact sponsorship. Athlete main income comes from sponsorship. Thus, public injury disclosure can lead to the big financial losses. In order to prove this point, we would like to provide you with a real-life example. The American football player Danny Amendola made a post detailing injury he received prior to match. Following the publication, Amendola lost a significant sponsorship deal with local Massachusetts healthcare provider. The reasoning of the company was exactly the injury and the public release of medical information. As a result, the loss of sponsorship affected not only the athlete himself, but also the well-being of the whole team. Dear judges, it is also evident from the numerous cases before the Basketball Arbitral Tribunal that sponsors tend to terminate their contracts due to disclosure of injury publicly. An example of such cases is the Arbitral Award 0841/16, where the player appeared as the claimant and was granted compensation exactly for the same reason. Similar event happened to the famous tennis player Nadal Djokovic, who disclosed his injury on social media. In this case, Djokovic lost his sponsor, who provided over 10 million a year. And even in addition to that, he was deprived of participating in a number of championships, including Australia Open. Therefore, regulation of injury disclosure is important not only to protect privacy of the athlete, but also to manage financial risks for both himself and team. Thank you.
Thank you. Now to hear the first rebuttal in the against position, University of Manitoba, you have 2 minutes.
Hi, is everyone able to hear me before I begin?
Yes.
Awesome. Okay. Thank you, judges, and thank you to our colleagues from Bulgaria for their amazing speeches so far. I'm going to do two things in this speech. I'm going to go over the arguments that my partner Samir made, and then I'm also going to refute every single line of attack that we've heard from the other side. First, we heard from the opposition that lack of regulation will lead to a violation of players' privacy. While we completely agree that privacy is an important aspect in an individual's autonomy, even athletes, however, in the realm of sports, the largest reason athletes live affluent lifestyles and are determined to be public figures and live large affluent lifestyles because of their profession is due to their presence in the public realm. And being in the public realm is sort of like being a large company or being a corporation that is in the public realm where people support you and people want to know what you're doing. So for example, sports teams like Manchester United, the Green Bay Packers are all public companies. On our side, what we tell you is that that is an important distinction because lots of people rely on these public shareholders or rely on these public companies, and they should be able to know what is going on. And players' injuries are a big factor in that realm. We think that this should be a calculated choice that teams and players get to make on their side. What was the second argument that we heard from the other side? The idea of manipulation and fixing matches. We tell you that when injuries are disclosed, fixing is limited and lowered, as Samir has told you, because you reduce the edge that an insider can have. Now imagine if something like the stock market had no public information displayed at all. That would be a huge disadvantage for the average trader. It would be easy to see the edge that insiders would then have. In the same way, in sports betting and match fixing, if you have no publicly available information, the people who have some sort of edges have a huge advantage, and we think that's unfair. And the last thing they talked about is that players might lose their deals because of publicly displayed information. Once again, we tell you that they should have the choice to make this information publicly displayed or not. We also think it's unfair to companies, unfair to anybody else who's investing time and money into these athletes that don't know the full information. Thank you.
Thank you. We'll now hear the second rebuttal, starting with the team in favor. Sofia University, you have 2 minutes.
Am I audible and visible again?
Yes, you are.
Thank you. As a second speaker, I would first like to address the arguments of the opposition. Regarding their argument about the competitive fairness, we actually believe that regulations on injury disclosure could promote more fairness, transparency, and reliable information sharing. Our solution is, instead of leaving injury updates to athletes and coaches, governing bodies and medical professionals could be responsible for providing accurate and standardized information to the public. Moreover, there is going to be a better balance between transparency and privacy by establishing clear guidelines for what information can be disclosed publicly. Moreover, there is not going to be less transparency in the games because there is always communication between the teams in the sports leagues. Not posting some information on social media doesn't mean that the opposing team will not be aware of the situation. It's very important to highlight that we're arguing for implementation of minimum regulations for the purpose of the well-being and protection of the athletes. We are not arguing that disclosing injuries on social media should be prohibited overall. Dear judges, this is also related to the second point of the opposition, about the importance of sharing information and collecting data. Please note that collecting data is still possible with our regulations and will even be more reliable. We are not prohibiting the disclosure of injuries overall, but only by the athletes and coaches on social media. Lastly, the regulations will prevent sharing some sensitive information by the coaches, like, for instance, mental health problems of the athletes or just other illnesses that are not directly connected to the athlete's performance in the games. Thank you.
Thank you. We'll now hear the second rebuttal from the team against University of Manitoba. You have 2 minutes.
Hi, everybody. I'd like to confirm that I'm audible.
You are.
Wonderful. All WHO member states have ratified at least one international human rights treaty that includes the right to the highest attainable standard of health. After ratifying a treaty, a country has a legal obligation to protect and fulfill the rights recognized by the treaty. The Office of the UN High Commissioner for Human Rights stated in 2008 that states have the obligation to protect, and that the obligation to protect requires states to prevent third parties from interfering with the right to health. In this situation, third parties are the sports leagues, and they must be prevented from interfering with the disclosure of personal health data. My opponents have brought forth protection from unwanted public attention as an argument, that preventing unwanted attention justifies policies against injury disclosure. But they fundamentally misunderstand that allowing athletes to choose whether they want to disclose injuries does not mandate them to do that, and if any athlete does not want public attention, they have the right not to share that information. Our argument is that they should have the right to choose whether or not they want to disclose. Athletes are athletes, but first, they are human beings deserving of universal rights and protection. According to Article 6 of the European Union's General Data Protection Regulation, collection and processing of data is only lawful if the data subject has given consent to the processing of his or her personal data. Making sure that the disclosure of all personal health data is predicated by consent is key, as having control over that information is incredibly important and can be read in as a human right in Article 12 of the Universal Declaration. However, the right to consent goes both ways. Just as patients should have the right not to have their personal information disclosed without their consent, they should also have the right to consent to disclose their own information as they wish. Our opponents say that athletes can lose sponsorships if they disclose information on social media. This is true. However, is that not their right to choose? If an athlete believes that disclosure is worth the risk, are they not an autonomous individual who is allowed to make that choice? Allowing social media disclosure is the only way to respect the privacy rights of individuals. Telling an athlete what information they can and cannot disclose is not only not in the spirit of competitive fairness and transparency, it also infringes on their right to control information about their personal health in allowing a third party to decide what is appropriate for them to do with their own information. For this reason, my colleagues and I must reject the proposed resolution. Thank you.
Thank you. We have heard the rebuttals from both sides. We'll now proceed to the conclusions, starting with the team in favor. University of Sofia's team, you have 2 minutes.
For the last time, am I audible and visible?
You are.
Thank you. I would first like to point out that the topic also includes sharing information by the coaches, and this could be seen as a violation of the right of privacy to the players. I would now like to thank the opposing side for their statements. Throughout the course of this debate, we have elaborated on why sports leagues should implement a policy against players and coaches disclosing injuries and other medical issues on social media. This is the only way that the best interests of the teams and the players can be protected. Dear judges, we firstly address the possibility for violation of the right to privacy of the players. We refer to Article 17 of the International Covenant on Civil and Political Rights and the Article 8 of the European Convention on Human Rights, which both prohibit the interference of the right to privacy. Unlawful interference of the player's privacy is unacceptable, regardless of the fact that athletes are public figures. We demonstrated that by the case of Van Hanover versus Germany. Secondly, we pointed out that the lack of regulation could lead to misinformation and manipulation of the match's outcome. We talked about how strategies before matches could be influenced by false information about an injured player. And we noted some of the national laws worldwide that give jurisdiction to the sports leagues in such cases. Lastly, the unregulated public disclosure of injuries could impact sponsorship. This is evident from the cases of Daniel Mendola and Nadal Djokovic that we provided. Another case that also proves this point is the Arbitral Award 0841/16 before the Basketball Arbitral Tribunal. We have illustrated through our arguments that the establishment of regulations against disclosing medical issues on social media by the athletes and coaches is important for the future development of sports in today's rise of social media, as well as for protecting the interests of the athletes. Thank you.
Thank you. For the concluding statements in the against position, University of Manitoba's team, you have 2 minutes.
Is everyone able to hear me?
Yes.
Okay, awesome. Thank you, judges. I'm going to do one main thing in this last speech. I'm going to break this debate down into the 3 rounds that we had, 3 themes that we had. The first big theme we had was about privacy. Okay, on their side on privacy, you hear the idea that athletes lose privacy. Yes, athletes lose privacy in the realm of being an athlete. That is something that goes along with the lifestyle they choose. They are in a public profession and in a public company. Sports are basically a business. But on our side, we tell you it's more important people give choice on what information is disclosed. And then we also tell you that policy should be implemented. They started their speeches by saying that the policy should be implemented and then started by saying giving a choice. And then same thing when they spoke about coaches, we tell you that they come under the same realm of being a business. This information needs to be put out there. This information has come with the profession that they have chosen. What was the second big theme we heard about? It was about match fixing and strategies. We tell you on our side, the edge is actually way higher for someone who is going to fix a match or do some type of illegal activity in terms of rigging a game when you have less information available to the public. It is much harder to rig or fix a match or come up with a strategy that can hurt another side when you have less publicly available information. We tell you that is an inherently flawed argument on their side. And the last big theme that we heard about in this round is that athletes and players might lose deals because of publicly disclosed information, whether it be from coaches or from the athletes themselves. However, we'd like to point out a big thing that most likely a company that is investing millions of dollars into a player will know that information. And in their contract, it will most likely say that they have to disclose this information anyways, whether it be put out on social media by a coach or a player. And that information is going to be given to them regardless. So that information being put on social media for the public's knowledge and for the knowledge of other companies like sports books or other teams will not affect that company's decision. They're going to have that information readily available to them regardless of whether it's posted on social media or not. Thank you.
Thank you. Good job. You have now concluded your 8th finals debate. You can now relax. You are no longer in the graded part of the debate. Well done on completing all your matches so far and completing this match, the first one in the final phase for your teams. The results will be shared with you as soon as we confirm all the scores from the judges, who have 2 days to review and score. Once the scores are confirmed, we are looking forward to sharing them with you, of course. In the meanwhile, we'll do a traditional feedback round with the participants on the call right now. So perhaps starting with the University of Manitoba, Ms. Andrews, to start us off, how did you find the debate and the topic?
I found the debate to be very interesting. I found that the prompt was very hard to frame from both sides through for the perspective of international law. Just because I don't really know a lot about international sports law. So that was something that I had to do a lot of research into. I also found it challenging because we're actually in the middle of a 3-day exam right now at the University of Manitoba for our first year law for our crim class. So trying to find the time to research for this debate and prep for it and also prep for the exam and finish the exam has been challenging. But hopefully we did an okay job. And you guys definitely had fantastic arguments on your side. So congratulations on that. I could see your preparation. It was evident.
Thank you for sharing, and hopefully also all the best for your exams. Thank you for connecting. Starting with Sofia University, Ms. Angelova, how did you find the debate and the topic?
I found the debate really interesting. Actually, I also really liked the points that the opposition made. They were really unique in my opinion and quite interesting. But yeah, for me also the preparation was quite challenging because the topic for sports injuries is not something that I had read on before. So I had to do a lot of research, but it was good and I enjoyed it.
Thank you for sharing. for University of Manitoba, Mr. Bular, how did you find the topic, the debate? Perhaps was this an area you were familiar with, be that in the area of law or just the topic-wise?
No, not really. I don't know too much about international sports law, but I do like sports, but it wasn't too applicable into this. But it was a really good motion. It was really interesting. Really made us think, and we had to get a little outside the box, as I think you guys can see. But yeah, it was great preparing for this. I wish it wasn't during exams. Maybe we could have done more preparation, but it was really fun regardless.
Thank you for sharing. Ms. Makishian of Sofia University, how did you find the debate, the topic, and perhaps was your preparation for the final phase a different one than the one you had in group phase?
At first, it was enjoyable for me to be at final with the team of University Manitoba. It was a pleasure for me to do research for our topic as I enjoy watching sports. It was really interesting and inspiring for me to discover new things about sport.
Thank you. Thank you for sharing. Mr. Harris, University of Manitoba, how did you find the debate, the topic, and perhaps did your team have a different approach in preparation in this phase, other than in the group phase, aside from trying to accommodate also your exam season?
Hi there. I really enjoyed today's debate. I think it was a really unique topic in that, as compared to maybe environmental law or nuclear proliferation, there's not a lot of international leagues to kind of compare regulations across different jurisdictions. So I think that added a bit of challenge to our work, but I think we did our best. I really enjoyed the arguments made by the University in Bulgaria, especially I think the opening speech was really crafted very well and the prose was quite excellent. I think our preparation for this round was, like my colleague here had said, a little bit outside the box to try and be a bit more creative. But nonetheless, I really enjoyed today's debate.
Thank you. Thank you for sharing. Mr. Kichikov, is there anything you would like to share with the students, having observed the debate and also supported one of the teams for preparation?
Yes, hello everyone. Firstly, congratulations. I think that this topic gave you a big chance to really be responsive and think really quickly on how to rebuttal the different arguments of both the teams. And I think that this match, particularly the atmosphere that I felt while watching this debate, I thought that the debate skills and the whole progress that we get to see during the competition is a very big achievement for not only for our team but for every team that is actively trying to do more and to really progress and develop.
Thank you. Thank you for sharing. And really, it's on the organizing side, we can confirm it's exciting. You can see it in the scores, of course. You can also see it in the confidence and argumentation style that the teams have during the debates. So we're only happy to contribute to it as much as we can. On that note, perhaps to find some more items on the common ground between the teams, I would like to maybe give you opportunity to introduce the go-to student association, perhaps, or the law association specifically, if you have one in mind, that is active for your faculty, for your university, and what kind of activities you usually do. And perhaps you might find out you might have quite a few commonalities as well on that aspect. Perhaps starting with the University of Manitoba, whichever one of your members would like to take the lead on this.
In terms of faculty associations, are you talking about like recreational stuff or more official things that we can do, like debating?
Oh, it can be both, but perhaps you have one that is for law students in particular that might give you opportunities to connect with alumni from your university or maybe practitioners in the field.
Um, well, we have a lot of different sports organizations out of Robson Hall. So, as you guys probably know, hockey is really big in Canada. Is like ice hockey a big sport in Bulgaria? Kind of.
Not really, but it's getting more popular, I think.
Okay, cool. Yeah, so hockey's really big in Canada, and one of the kind of alumni and student associations that we have is the hockey league, so the Law Hockey League, and they call up law students to play on firm teams. So you get the opportunity to play hockey, which is very fun, and to mix with the various alumni from Robson Hall and other law schools and people in firms. So that's kind of a fun example of a very Canadian twist on a law school organization.
Absolutely, that's quite an interesting one. Thank you for hearing. Maybe your colleagues would also like to add.
They do the same thing with like basketball and other sports too, and then they also have lots of events where like people who work at firms and lawyers will invite all the students to their workplace and like for drinks and just a chit chat. So they do a lot of stuff like that.
Right. Well, then also for Sofia University's team, what about you guys? What would be the student associations or perhaps law student associations that comes to mind, and what kind of activities do you usually experience with them?
Right now, it's kind of hard for me to think of a particular law association because I'm still in my second year and I really didn't really explore them. But I know that there is association, I think it's called ELSA, that it's international. I think it's for many countries in Europe. And they do many competitions, particularly for law. And also, yeah, we, as the Canada team explained, we also have some sports competitions between the faculties, but they're more likely in football or soccer, as I think they call it in Canada, and volleyball, basketball. I think those are the most popular ones. Maybe Martin and Sophie could also elaborate because maybe they're more in touch with the topic.
So basically, in regarding the law, we have a law debate association in the law faculty, which connects all of the moot court competitions and debate competitions. And that way, students can easily access and gather information about how to join a certain team, when to join it. And this is actually something that is pretty valuable for all the students. Because you don't need to search in a lot of different places in order to find information. When we're talking about sports, we have annual football, soccer tournaments. Um, I don't know about any other annual competitions. We have the day of the sport every year, where when you can actually go to the different faculties of Sofia University and you can see different sports, for example, table tennis, regular tennis, and all of the different sports that we have in Sofia University. And also one interesting thing, I'm not sure if in Manitoba is the same, but actually during getting your law degree, you need to, sports is mandatory. You need to do it like every year, I think, or it was up to the second year.
Up to the fourth year.
Oh, yes. So,
Yeah.
yeah. So I think it's interesting. I'm not sure if in every law faculty it's like that.
No, I know that we don't have a mandatory sports requirement for our degree, but that does sound like a very interesting idea. I mean, we in Manitoba are a very sporty bunch, like Tia and Kira talked about. We have a lot of student and alumni law games and different sports activities, so maybe that's an idea that we'll look at.
Oh, perhaps an interesting collaboration might be in your future. Maybe the next meeting outside of the competition between the two teams could be first inter-university plus student sporting event, intercontinental even in this case. On the side of organization, we can only encourage you to stay in contact, be that on the individual level or on the organizational level. Absolutely, we see that you have quite a few commonalities over the course of the competition and also in this match in particular. So really, if you have the opportunity to come to The Hague and to meet each other perhaps as well, that could be first step to meeting in person. Maybe and the next one could be actually organizing some events together between the faculties or your student associations that might take the organizational steps for it. For traveling to The Hague, we do have a support from KLM or Air France. So in case you will be considering traveling to The Hague and looking at tickets and flying through with those carriers, do let us know, as we have a discount code that we can share with you to make this a bit easier experience. The final week will be taking place in The Hague on the week of 19th of June. So the final debates will be with the 4 teams that qualify for quarterfinals. My apologies, semifinals, and that qualify from quarterfinals. And the week itself will be filled with visits to international organizations, some networking opportunities as well in the city, and you'll also have the possibility to meet the participants from the sibling competition of the Hague Inter-University Law Debate Tournament, the concours, which will be also concluding in the same week. And on that note, I just want to wish you all the best, and once again, congratulations.
Thank you.
Thank you, everyone. Have a good rest of the week.
Thank you. Have a good night.
Thank you. Thank you very much.